Ladies and gentlemen, please welcome to the stage Global Policy Director and General Counsel, Chamber of Digital Commerce, Amy Kim.
Someone was much taller than me. So good morning, everyone. I'm pleased to be able to introduce our next segment discussing the expanding interest in smart contracts, led by our friends at Perkins Coie. Before they dive into their discussion, though, I'd like to set the stage a little bit. The concept of smart contracts has taken on new interest in the last few years. While it's been around for some time, smart contracts have taken on new meaning with the growth of blockchain technology. They have the ability to automatically execute portions of agreements or entire agreements based very simply on an if-then principle. When used on a blockchain, they can automate things like payment functions based on data inputs, for example, and record and track those functions over time. Many in the industry see incredible promise in their use in blockchain-based applications. Given this interest, in the last few months, we've seen a number of states and state legislators acting to enable state law to advance this technology. This effort started last March when Arizona enacted the nation's first law specifically recognizing the use of smart contracts and blockchain technology in electronic transactions. Following Arizona, in the new legislative session and through January and February, we've seen 6 more states, New York, Nebraska, Florida, Tennessee, California, and Illinois, have introduced similar legislation in the past few months. These proposed bills seek to amend their state's electronic signature and electronic record statutes to include smart contracts and specifically recognize blockchain technology under state law. We appreciate the thoughtfulness and leadership that these states and these legislators have taken to promote blockchain technology and smart contracts. And in several cases, these legislators have also introduced other legislation involving blockchain or the technology or the taxation in an effort to promote the industry, which is truly inspirational and supportive, especially during a time when perhaps we're seeing some differing signals on the federal level. In the very specific case of smart contracts, however, we believe that additional legislation is not necessary. Laws already exist that permit the use of electronic records and electronic signatures in commerce. These are the Electronic Signatures in Global and National Commerce Act, also known as e-sign, as well as a uniform state law called the Uniform Electronic Transaction Act, or UETA. These laws say that where a law requires a record, an electronic record suffices, and where a law requires a contract, an electronic contract suffices. They do not say that it applies only with respect to a specific protocol or a specific technology. If they did, you could conceive a situation where we would need additional laws to recognize other types of technology, perhaps cloud computing. You think of any type of technology that comes online, you may need to amend the laws to encapsulate each one. The e-sign Act and the state UETA laws were designed with the future in mind and designed to ensure that you didn't have to do that on a technology-by-technology basis. Moreover, the e-sign Act has preemption provisions in it that need to be considered when you're modifying the state-specific laws in this way. So it's our view that additional legislation like this has the potential to confuse the marketplace and potentially even hinder innovation with respect to smart contracts. Some of you will recall the discussions that we've had, and yesterday too it was mentioned about the patchwork of state money transmitter laws. In that case, you have 50 states plus territories in the United States that have differing legislation with respect to the licensing and oversight of money transmitters. We are at risk of similarly impacting the industry with respect to smart contracts. So it's within this context that it's my pleasure to introduce this discussion on smart contracts, what they are, and some of the legal considerations surrounding them by our friends at Perkins Coie. First, Dax Hansen, who probably needs no introduction to many of you. He's a partner in Perkins Coie's Seattle office, and his practice focuses on issues germane to blockchain applications and business. And his colleague, Laurie Rosini. Dax is the chair of our state working group, and Laurie has been instrumental in helping us at the Chamber compile our state working group's State of the States report, which details all the legislation that's going on in the states relating to blockchain technology. And they were also helpful in working with us to develop this policy position. They're also going to discuss their a white paper that they're working on called Legal Aspects of Smart Contracts Applications, which I'm excited to read. So here to talk about that today, please welcome Dax Hansen and Laurie Rosini.
Well, thank you, Amy, and it's nice to be here. By the show of hands, how many people are either modestly or significantly confused about what a smart contract is? I'm in that camp. I've been in that camp. And I've been doing blockchain work now for about 7 years. I'm also a lawyer, and I've drafted my fair share of contracts. It occurred to me a little over a year ago that there was something happening that I didn't fully understand around smart contracts, where my clients were talking about smart contracts, but they weren't necessarily linking them to legally enforceable contracts, the type that I understood. But instead, they were talking about them in the context of transactions, software-based transactions, or sort of like rules engines that they were developing for certain blockchain and cryptocurrency type applications. So we set out as a team at Perkins Coie to try to demystify smart contracts ourselves to understand what they were, and then to share some of our insights from a legal perspective with others around us. We published a white paper in May of last year on smart contracts, and I'm pleased to announce that this morning we posted an update to that report, which is on our blog, virtualcurrencyreport.com. Laurie and I are going to spend just a few minutes here discussing what smart contracts are, both from the perspective of some of the initiatives and the academic research in a legal contract sense, but also in the application and use case sense. And it's going to be a little bit like drinking out of a fire hose here, since we have a lot of ground to cover in a short period of time. But Laurie, why don't you start us out and tell us how you define a smart contract?
Well, part of the challenge in speaking about smart contracts and understanding what they are is that there are multiple definitions floating out there. So the concept of a smart contract originated in 1994 with Nick Szabo, and his original vision was that it was a set of promises that could be in digital form and executed upon using protocols. It developed from there into really two tracks. You have one track of folks who are looking more at natural language contracts and how we can take these natural language contracts and put them in digital form. And then we have what we see today as Ethereum-based smart contracts. And Ethereum-based smart contracts are really computer code that work within an application, a distributed ledger technology application. They're event-driven. They're fed by conditions that then trigger a response. So the smart contract code has the ability and the authority to take possession over assets and transfer those assets once the conditions have been met. So when we, as a blockchain community, refer to smart contracts, this is the smart contract we're referring to. It gets a little confusing when we hear statements about smart contracts that are really meant to apply to what we're going to call in this room smart legal contracts. That's the other track of the natural language contracts. So often what we hear about the smart legal contracts is they're going to replace attorneys. I'm happy to say that that's not the case. In fact, I think we will survive a nuclear holocaust. There there certainly needs to be somebody around to litigate that matter. But in a typical contract, you have some primary aspects of it. You have formation, you have the terms of the contract, what are you contracting for how long, how is it going to play out, what are the responsibilities of the parties. You have the boilerplate, that's all the legalese that nobody reads but your attorney, and then the signatures. So the natural language contract initiatives are trying to find a mechanism for digitizing that. It's a little bit challenging, but there are some industry initiatives out there, and I encourage you to look into them because they do have some very interesting initiatives, particularly in low-cost legal solutions. But today we're going to turn it more to blockchain-based smart contracts.
So I think it's worth noting that in addition to those initiatives are focused on legally enforceable contracts and how you might meld code into them or even build automated features into the contracts. For instance, an example of that would be an independent contractor agreement that allowed for payment to be made not on a weekly basis or a monthly basis, to be made on an hourly basis to some sort of a wallet address to the employee or to the independent contractor. We're seeing some wonderful innovations in that regard. But in addition to just to those, what I'll call somewhat narrow focused initiatives, there are also some broader initiatives focused on what smart contracts are, and included in those initiatives are the initiatives of the Chamber, the Smart Contracts Alliance that was launched, I think, over a year ago, and more recently the Token Alliance, which is looking at these ICO, so-called ICO or token sale projects that run specific applications and the legal issues associated with them. But where I first saw a smart contract in any sort of application or in the work that I do daily was in the context of token sales. Of the initial coin offerings, and that was that there are two things. That there was a token that was being created, that in itself was a smart contract. The way it is created in Ethereum is through a smart contract, where an address is created, some recipients are designated, some rules by which that token will be administered are released in the context of a quote-unquote smart contract. Then more specifically, if I were to send in Ether into the seller of a token, that would go into a smart contract address, and I would be sent back a special purpose token. That is an automated escrow release type function that is in and of itself a smart contract. So this is where I've seen a smart contract in practice. That's where we've seen it over the last year in earnest, and I think we will see more in the legal context, but for now we're seeing it in a very practical technology sense. There are legal agreements that surround that whole process, token terms of sale, for instance, or other agreements that are very much the traditional type of contract that we all know and love, and there's nothing really smart about them. They're just electronic contracts, as Amy was describing, that are accepted through some sort of a click. This is where smart contracts face us here and now, I think, in the everyday sense. We do think that we will see more smart contracts in day-to-day use in a number of different industries. And I think that we are seeing more in these industries as we speak. In fact, there's been a significant amount of development in the capital market space over the last couple of years. But we think that there are other applications like supply chain management and government records and real estate registries and self-sovereign identity, where we will automate more of these transactions. We will create them so that they are unstoppable. They are able to respond based on certain inputs that we call oracles, certain interest rate triggers, or certain temperatures or certain reports from carriers or shippers or other participants in the ecosystem to complete an if-then statement. And the opportunities are pretty significant. We think there are legal risks associated with smart contract applications, and they will depend on the type of activity or use. And so it's hard to I guess, buttonhole the consequences associated with them. There are tremendous legal issues associated with them, but there are also enormous opportunities. And there are green fields ahead, I think, in terms of how one can automate transactions that have been inefficient and manual up to this point. So Laurie found a picture of our ninja mouse. We found that many of the people in the industry here are ninja-like. They can find a way to accomplish their goals here. So in terms of opportunities, just as an example of things that we've covered in our updated white paper, we cover the capital market space. And what we've seen is the ability to effectuate post-trade settlement, to create standardized contracts, to create the ability to track and to trace and to develop reg tech type solutions. So it's very promising. In fact, just from my vantage point with the whole cryptocurrency and blockchain space, we saw it all launch with Bitcoin, which is very much payments driven. But the next industry to get interested was the capital markets space. The financial industry saw the opportunities. And following behind, I think, are industries such as insurance and healthcare and other regulated spaces here, pharmaceuticals. Laurie, would you like to try to decipher the regulatory landscape a little bit when we think about smart contracts?
I don't know if that's possible. So the regulatory landscape that governs capital markets and financial activity, financial institutions in general, is a myriad of legislation that was enacted over the course of the last 20 years to address generally crisis situations such as Dodd-Frank. So what we have is we have a lot of overlapping and somewhat confusing and very dense regulation touching on capital markets. So any activity that a participant is going to engage in is going to be subject to that body of regulation. On top of it, you have now introduced any legal issues or concerns arising from the smart contract itself. The legality of the smart contract, issues particularly in a peer-to-peer environment as to who is subject to the regulations, and other concerns when you introduce oracles and human inputs coming into the contract to feed the conditions. Those are all legal issues that are going to be arising in the context of smart contracts, layered on top of the already complex regulatory infrastructure.
Sorry, so flipping through, we had another slide with some cues here in terms of how to analyze these things. But I think if you're going to no, you're not out of order. We had something on the right-hand side. We just got our slides outdated. But so Laurie, how do you think about the regulatory landscape? What are the tips for analyzing these things?
Well, when a client comes to us, we receive a white paper that describes what it is they're looking at doing, and we need to get fairly deep in the technology and really understand the movement of the asset, the movement of the funds, and understand the activity at a deep level so that we can compare it to the regulation, which in a typical analysis will include a securities analysis, an analysis of commodities laws, anti-money laundering, sanctions laws as governed by the Office of Foreign Asset Control, state laws, consumer protection laws, and various other potential issues depending on the application.
So that, in our view, is something that applies every time you have a token-based smart contract. You have to at least run through those types of legal issues. In addition, if it's not a token-based smart contract offering, and there are many of them that don't have nothing to do with tokens and nothing to do with token sales. In fact, many of the opportunities, I think, are unrelated to tokens. In those situations, there are a host of other legal issues related to just the smart contract itself, which could include things such as e-sign and state electronic contracting. We could also have things related to enforceability. In the context of the particular activities that a smart contract can accomplish, escrow release or information release or some other automated if-then statement, you may have a whole host of other issues. You may have to look at things like the UCC law around digital certificates of title, or looking at the tax issues, or looking at sanctions laws, or a whole host of other activity-specific issues. So it's hard to quantify those, but we started a list, and we're going to overpower the slides because really smart contracts start to pull in about every area of the law. But maybe as an example, we can touch on supply chain.
Absolutely. So supply chain management is a very complex industry. It typically involves a myriad of distributors and manufacturers across a global scale. And so it is touching on not only U.S. federal laws, but it's touching on foreign laws and maritime law. And for example, Dodd-Frank introduced some provisions regarding the transparency of supply chain management. You have anti-bribery laws in the US as well as in the UK. You have anti-slavery laws and various employment issue laws that pertain to the actual goods that are being moved through this supply chain. And all of these come into play when you're looking at a smart contract solution for supply chain management. It's very complex, and we don't imagine we're going to see any practical examples of it in play for quite some time due to the complexity, but it's definitely in development.
Maybe to touch on one of the topics that Amy mentioned here in closing, we are seeing a number of jurisdictions outside the United States and in the United States encouraging the development of blockchain technology and trying to help. And we've heard many regulators ask and legislators ask, how do I help the cause? How do I bring this innovation into my jurisdiction? And some states in the United States have started out with a bill that's meant to encourage smart contracts. As Amy said, we don't think it's actually necessary. We appreciate the support, and I think there are other ways that the industry could be advanced. But in many ways, introducing the type of smart contract statute in the states may be counterproductive in the sense that it further adds to the confusion when we talk about a smart contract being not denied its validity simply because it's executed or tied to some sort of blockchain or some sort of digital currency type application. That confuses things in part because, as we said at the very beginning, many smart contracts have nothing to do with legally enforceable contracts. They're just meant to be software-based and technology-based transactions. So we think that in many instances, the e-sign and the Uniform Electronic Transactions Acts in the various states already cover these internet-based, these protocol-driven, these encryption key-oriented transaction types. So we don't need the additional state component. Laurie, do you have any final comments?
Well, I'd like to add in regards to the state initiatives, if you wouldn't mind scrolling back.
Sure.
As you can see, it's a well-crafted definition there to both blockchain technology and smart contracts. But the problem is that once it's coded into law, it becomes static. And the law is very slow to change, and the technology is moving very rapidly. So what we like to avoid are these statutory definitions of this at play in this industry that will box in the players into a specific definition. We would like to be able to foster the development without having these static definitions.
And I think it's fair to say that I think that the Chamber's position is, in many of the industries, is that we should not regulate technology. The only thing that should be regulated would be specific types of regulated activity. If you are engaged in a financial transaction, in a custody transaction, these are all fair game for regulation, but we should encourage the development of blockchain, distributed ledger, smart contracting technology without the legal baggage that goes along with, for instance, a patchwork of different laws. I mean, the money transmitter laws are already hard enough to navigate on a state-by-state basis. I guess in conclusion, we'll just ask that if you have comments about our white paper with smart contracts, we'd love to see it. We have it posted at our blog, Virtual Currency Report. But this is a fast-moving topic. There's a lot of interest in it. We know we don't have all the answers, and we'd love to get your feedback. Thank you for your time.
Thank you.